Tonight what has changed is that there is now a joint instrument that has legal force, and if I could draw the committee's attention to paragraph 12 of that, where it says it would be inconsistent with the obligations under Article 5 of the withdrawal agreement and Article 2.1 of the protocol for either party to act with the objective of applying the protocol indefinitely. So the concern that we sought to address with the EU was there was a very real issue, and I think it went beyond parties, as to whether the backstop would be used as a vehicle to trap the UK and through doing so in essence distort the negotiations themselves. And in essence the EU were acting in bad faith in order to have negotiating advantage, and that is the ill that the joint instrument seeks to address. And that is a significant change that has been secured, and it is something that the Attorney recognises in his legal advice, which I think has been published and shared.
And I shall come on to, but I'm just trying to understand what actually has changed, because in the paragraph you've just referred to, it says, should the Union or the United Kingdom consider the other party was acting in this way after the protocol became applicable, it could make use of the dispute settlement mechanism. Now, the dispute settlement mechanism is in the withdrawal agreement, and it says that any suspension, which is what the David Liddington referred to in the House last night, shall be temporary. So could you explain to the committee where a suspension that shall be temporary can become a unilateral right to withdraw for the United Kingdom? Because I don't see that the withdrawal agreement makes any such provision for that whatsoever.
Well, if I can take you to the Attorney General's legal advice, because he speaks to that very issue at paragraph 17, where he says that he considers that the legally binding provisions of the joint instrument and the content of the unilateral declaration reduce the risk that the United Kingdom could be indefinitely and involuntarily detained within the protocol's provisions, at least insofar as that is brought about by bad faith. So the point I'm making is the issue that came through in many of the debates we had in Parliament was this issue of the EU, which I don't, for the record, believe is the intention, because actually it's in both sides' interest to get on to the future economic partnership. I think that's the EU. I think they will approach this in good faith. I think it's not correct to suggest otherwise, but it was clear that a number of parliamentarians had that concern as to whether bad faith would be a vehicle for trapping the UK and more distorting the talks. And that is an issue, as I say, that is given legal force. Could I also, Chair, just draw your attention to something which I think speaks very much to the issue of the debate around bad faith, which is paragraphs 7 to 11 of the joint instrument, because what that does is set out a process for the alternative arrangements, and a number of members of the committee will know well that the Brady Amendment specifically focused on the risk of going into the backstop. There's two aspects. There's one, do we go into the backstop, and then do we get trapped within it? And again, one of the things in the negotiations we've focused on is how do we, in response to the concerns parliamentarians had around the alternative arrangements, how do we use the alternative arrangements to ensure we don't go into the backstop? And what the joint instrument does is give a clear date and a clear time frame, which is a legal commitment on both sides to have alternative arrangements in place. But importantly, and we may get onto this in due course, because one of the reasons we couldn't do this immediately was it required derogations from the EU. And the point of the text is that in looking at the arrangements that sit alongside that technology, the EU can't unreasonably look at arrangements to enable that technology to function. So that is a major safeguard, meaning that we're far less likely to go into the backstop. We've got the triggers, the Swire Amendment, whether one votes to go in. But the alternative arrangements set out, as I say, at powers 7 to 11, is extremely helpful, again, in addressing, particularly, if I may say, from more those colleagues with a more Brexit concern, as to whether you would actually trigger the backstop in the first place.
Now, the Attorney General in the legal advice just published. Would you mind? Well, can I just finish the point, and then I will absolutely. The Attorney General has said that what has been negotiated reduces the risk that the UK could be indefinitely and involuntarily detained within the backstop, insofar as it's been brought about by the bad faith or want of best endeavours of the EU. So can you just confirm it doesn't eliminate the risk that the UK could be indefinitely and involuntarily detained in the backstop? Is that correct?
Well, if I take you to paragraph 12, so what it says is if the UK could demonstrate the EU was acting with the objective, the protocol indefinitely, that would be a breach of good faith, and that's about a pattern of unjustified delay. And those obligations are then subject to arbitration under the dispute recognition. That's the basis, as I said a moment ago, on which one could suspect. So what's important is the interplay between different components of this, and I appreciate the committee have only just had an opportunity to look at this.
Although the sentence you've just referred to says if the UK would be entitled to take measures to disapply the provisions of the protocol, but actually the withdrawal agreement provides for temporary suspension. It doesn't provide for disapplication. But let me come back to the question that you haven't answered. The Attorney General says it reduces the risk of indefinite detention, in effect, in the backstop, but it doesn't eliminate it. Can you confirm for the committee it does not eliminate the risk?
Well, I mean, look, the Attorney will answer in more detail, but my reading of that is the distinction is because one has to prove bad faith. So to say it eliminates it ignores the fact that one also has to prove bad faith. That's why a moment ago I was referring to the interplay, because what is set out in the documentation through the timetable, some of which was there in the letters from President Tusk and President Juncker, the commitment to start more quickly, so not waiting for ratification, that we can start as soon as the withdrawal agreement goes through, having the alternative arrangements timeframe, having a clear programme, actually means that if that is not met, it becomes much easier to display that bad faith has occurred, because self-evidently there's a commitment on both sides to have alternative arrangements in by that date. So it gives a much clearer time frame. And let's remember, this is both a legal and a political assessment that the House is making. And one's got to make a political assessment also as to where those balance of risks.
Bad faith is not the same as an intractable difference, is it?
Well, bad faith has its own definition in law, and it's a question of proving that. And what the attorney's advice says that basically if there was a pattern of unjustified delay, so for example, if the UK and the joint workstream on alternative arrangements came forward with sensible, proportionate arrangements linked to technology that is provable, then the EU could not simply say, well, we're not going to have any flexibility in our approach, we're not going to implement those. So there needs to be a look at what the political reality would be, as well as what the legal requirements
would those proposals from the UK in those circumstances have to be backed by the arbitration panel?
So it would be actually this teases out one of the areas that gets misreported in the press in terms of the interplay between EU law and...
Would it have to go to the arbitration panel?
If we triggered if we made the accusation of bad faith, that would go to the arbitration under the joint committee. But that would look to the ECJ to interpret EU law, but it is an international body, and it's at an international level that it would adjudicate.
So the arbitration panel would have to decide in the first instance that the EU was acting in bad faith, number one, is that correct? Yes. Yep. Number two, if there are any questions of interpretation of EU law, they wouldn't be decided by the arbitration panel, they would go to the...
But that is the standard, Chair. I mean, international...
No, you just have to say yes, that's all.
Yes, well, yes, indeed, yeah. I mean,
and any ruling from the court... Hang on. Any ruling from the Court of Justice would be binding on the arbitration panel, the EU and the UK. Is that correct?
No, the arbitration...
It's a simple question, yes or no.
Yeah, well, you're asking it in a leading way, so if with respect, let me answer it, because I am answering it. It is the way international arbitration works, that they make judgments of fact, not of law. That is how international arbitration works, and the attorney is a leading exponent of this, so we'll elaborate in more detail. But that is how international arbitration, that is why sovereign states with their own legal frameworks enter international arbitration. What the arbitrator will do is assess the facts. So have sensible alternative arrangements been brought forward? Is that technology workable as a matter of fact? That is not a judgment of international, that is not a judgment of law. Now, if he needs or she needs an interpretation of law, yes, that is a competency of the ECJ, but that is not, in terms of what the joint instrument sets out, where the focus of the arbitrator will be, because it will be whether, particularly on the alternative arrangements, this is technology that exists, and we know from the work that's already been done that actually this is technology that exists, and what then needs to be looked at is on the facts, whether either side has acted unreasonably in not bringing forward their proposal. So it's a factual question the arbitrator will make, not a legal interpretation.
And if the UK loses its case before the arbitration panel, in other words, the arbitrator says, well, I'm afraid we don't think that these are suitable alternative arrangements, then the UK will not be able either to have a temporary suspension or to seek to unilaterally withdraw from the backstop. Is that correct?
Well, insofar as both sides are still working to a future economic partnership, so yes.
Is it correct that if we lose in front of the arbitrator, the UK, that the UK would then not be able to suspend the operation of the protocol? Is that correct?
Yes, because we would need to demonstrate.
Well, clarify. And the final point I want to put to you.
Well, would you like me to answer the question, Chairman?
Well, you said it was correct. Well, I just asked you whether it was correct, and you said yes. Well, if it is correct, that's all I was trying to establish, that if we lose at the panel, then we cannot suspend.
Well, not if there has been prima facie bad faith. So the point is, it's not that the arbitrator is sitting there in judgment as to whether the legal interpretation is X or Y. That is not the question they're answering. What the question is have both sides on the facts, and this is a standard test that sovereign states enter into. This is the standard of which international arbitration is conducted. As an objective test of the facts, has there been bad faith? For example, on alternative arrangements. And this is where the wiring comes in terms of the commitments on timescale, the firm date that is now in the text by which alternative arrangements, and in having that date, you therefore don't go into the backstop in the first place. Now, if you then go beyond that, what the text also does is it then makes timing of the essence, it doubles in essence the premium of time, and that is set out in the documentation, which again would give the arbitrator further weighting to that issue of fact. So it is not a question that the arbitrator sits there as a judgment of law. What it is doing, it is saying, have sensible arrangements been brought forward, or have the parties acted in bad faith? And I come back to the central debate that came up time and again in the chamber, which was the concerns of many parliamentarians around this tension between what is in the withdrawal agreement, which is temporary, and the concern the House had that it would be indefinite. And that really goes to the first question about whether one needs to change the text of the withdrawal agreement. The point is, the withdrawal agreement already has language saying it's temporary. What many colleagues were concerned about was the tension between the temporary nature within the withdrawal agreement and what's referred to as unless and until, and whether that would therefore have an indefinite nature, and how those tensions play through. And that's what we've sought to address in the joint instrument.
That's very helpful. John Whittingdale.
Can I just pursue this theme very slightly further? The Attorney General's final paragraph essentially says that unless you can show breach of faith, rather than simply intractable differences, nothing has changed, and the UK has no intentionally lawful means of exiting the protocol arrangements save by agreement. And when it comes to whether or not the difference is due to actual breach of faith or is simply intractable differences, that isn't really a question of fact. It's a question of opinion as to whether what is in the mind of the people undertaking the negotiations. So what confidence can we have that actually breach of faith stands any chance of being upheld? The EU simply turn around and say, no, we're trying to find a solution, we just don't believe that what you're suggesting works. That becomes an intractable difference.
Yeah, so what you quite rightly draw out is the distinction between whether there has been bad faith or whether both sides are still negotiating in good faith but have not got to the outcome.
Oh no, intractable differences means you've stopped negotiating. It means there are intractable differences. That doesn't necessarily mean bad faith.
Well, you can have a situation where both sides are still negotiating in good faith, and that's why the way out of that is through the arrangements, and that's what it says. But the central question that came through the debates we had in the Chamber was this sense that the EU were going to act not in good faith to reach an agreement with the United Kingdom. The charge that many colleagues in the House had was the opposite, was that the EU were going to act in bad faith, and that the backstop was this vehicle to distort the negotiations and trap the UK. Now, if you trap the UK, you are de facto acting in bad faith. You are trying to distort the talks for negotiating advantage. That's
but you have to
the
prove
concern.
Bad faith. And if the EU aren't going to say, actually, we're never going to agree to anything you come forward with, because that would be bad faith. But if the EU say, look, we'd love to find a solution, we simply don't agree with you about the viability of the one you're proposing, that is an intractable difference, and it means we can't leave.
Which is why, and I referred to it, and it's paragraph 9 of the Attorney's advice, where he addresses the fact that if de facto the relationship has become permanent, then by its nature it is not temporary. Now, if both sides, one's got to, I think it's worth taking a step back, both sides have given a commitment to put a future economic partnership in place by the end of 2020. The question then is, at what point does that no longer become temporary as you go past that? Now, as I say, the aim is not to go into the backstop. That is what the work stream, which I did with a number of colleagues in the House, in terms of the alternative arrangements, and that's where we've made significant progress with a clear time frame and a commitment from the EU on that. The question, though, is beyond what both sides have agreed, at what point would it become de facto permanent? And at that point, to what extent does that mean bad faith is occurring? Now, if both sides are negotiating in good faith, then of course that negotiation will continue.
I'm afraid I don't want to pursue. All I would say to you, Secretary of State, is that the conclusion of the Attorney General's conclusions, which is the last paragraph of his letter, reads very much as if nothing actually has changed. And obviously I'm not a lawyer, I'm waiting for advice from my colleagues who are lawyers, but that final paragraph is pretty terminal.
Well, it's a long time since I was a lawyer, and I defer to the Attorney General, who is a far better lawyer. But I don't accept that, because, as I say, one's got to look at this as a package, not in isolation. And I accept the point that if both sides are negotiating in good faith, that is what the final paragraph is referring to, and therefore there will need to be an arrangement. The central political concern that was raised during the first meaningful vote was that the risk was that the EU wouldn't enter into negotiations in good faith. The concern was that they would use it as a trap. And the point there is there has been a strengthening, and the Attorney's advice recognises it. And with respect, we can't cherry pick and say, well, he says there is a reduction of risk and therefore that is binding, but in 2 paragraphs or 3 paragraphs earlier, where he says there is a change to the legal risk, we're going to skirt over that. And I think it's important one takes that at the whole. Also, if I may say, it's worth referencing back to his earlier advice of the 13th of November, where he said, actually, ultimately, these are questions of a balance of risk, and that politically it will be in the interests of both sides. Now, that didn't persuade the House, and that is why we've sought to address the particular concern that the House had about this issue of bad faith. Now, it doesn't go as far as you would like, Mr. Whittington, I accept that. But it does allow for this issue of bad faith and the UK being trapped. And that is the issue that politically kept coming up in the Chamber.
Okay, Jonathan Ginogly, thank you.
Well, actually, Chair, I was just going to look at what John Whittingdale's just said. I mean, John asked in the context of the agreement overall, and bad faith does apply to the agreement overall. The Secretary of State kept referring to alternative arrangements, presumably because that is an issue of significant concern to certain members of Parliament. And the alternative arrangement section, I think I'm right in saying, the need to work towards them is not in the binding section. And therefore, specifically on alternative arrangements, the question arises is what level of inaction in working towards getting those alternative arrangements would constitute bad faith. And I don't think the Secretary of State has actually nailed that answer.
Okay, well, if I may, just trying to help on that. So the joint instrument is legally binding text, and that does set out the arrangements in terms of alternative arrangements. So it does put that onto a legal footing, and that is something, therefore, that any arbitration panel would need to look at. So there is legal force to the timescale commitment on alternative arrangements. That is in the joint instrument.
No, but I was talking, Chairman, more specifically about the need to work towards getting those alternative arrangements. At what point would bad faith apply?
Sorry, say again.
At what point would bad faith be arguable in the context of not working towards the alternative arrangement?
Well, I think that's addressed in the AG's advice. So where he says where there's a pattern of unjustified delay, that would be the issue. And there is a clear, paragraph 7 to 11 of the joint instrument sets out a process whereby, in essence, momentum needs to be put into the alternative arrangements, and that this is legal text. So those paragraphs 7 to 11 of the joint instrument are legal text, and it makes time very much of the essence. So basically what you have there is something that has legal force, that the arbitrator would need to consider, and that it sets out that alternative arrangements which supersede the protocol in whole or part are not required to replicate its provisions in any respect. So one of the discussions we've had is around to what extent the alternative arrangements would be constrained because of the derogations required for the single market and the protection of the single market. And again, what this is saying is that there must be flexibility on both sides to look at how that technology is applied. But this, in the joint instrument, does have legal force.
Okay. Now, Richard Graham had one very quick question on this point, and then I'm going to...
Specific point, Secretary of State. Jean-Claude Piry, the former Director General of the EU's legal service, has said very clearly that it's important that the EU did not object to the UK's unilateral declaration. In the case of the EU dragging its feet and not acting in good faith, the UK could ultimately suspend some of its obligations, but not on the rights of citizens. And he then reinforced the point by saying, with this, the UK has a legal remedy not to be trapped in a customs union with the EU. Now, the key question is, do you agree with him, and is that correct?
I do. So I think what Pires has said over the last 24 hours or since last night, I think is interesting in two regards. I mean, he's one of the authorities on EU law from their side, from the EU side. And I think, firstly, he has said that a unilateral declaration does have force if it's not objected to on the other side. And that is our understanding. So what is that there? So whilst it is a UK assertion of our interpretation, it actually goes beyond that, and I think that is again an accepted position in international law. And I think the comments from Jean-Claude Pires reinforce that. So the unilateral declaration sits alongside the joint instrument, and it makes clear the UK's understandings of the temporary nature of the protocol. So there is legal benefit to that.
So
but the other point is...
Isn't that the ultimate security then? Isn't that the answer to the question that several colleagues have been asking you? Could we get out if we wanted to? Yes, we would use the unilateral declaration.
Well, it is because, I mean, the joys of Twitter and people expressing their views on Twitter, and he has tweeted that the UK has a legal remedy not to be trapped in the customs union with the EU. So I think part of the reason why the Prime Minister has had to negotiate so hard, part of the reason why the negotiations were going on as late as they were last night, is because from the EU side, these are material commitments that they have made. And I think sometimes the frustration, and we saw this with the, I mean, it's a separate debate, but when Lord Guthrie and Richard Dearlove came out and said the political declaration contradicted our national security. And they are two of our most respected public servants, and so I hold them in very high regard. But there was a central contradiction in what they said between critics of the political declaration saying it's not worth the paper on and it has no legal weight, and then the same critics saying but the political declaration is so binding that it constrains our national security. And I think that's part of the contradictions we get in this debate.
Thank you, very helpful. Jacob Rees-Mogg.
I want to follow on exactly from that, on the unilateral declaration, to see exactly how unilateral it is. The end of it says that the disapplication of obligations on the protocol in accordance with Part 6, Title 3 of the withdrawal agreement. Now, Part 6, Title 3 is paragraphs 167 to 181 inclusive of the withdrawal agreement. That is the dispute settlement procedure. So it's only a unilateral ability subject to the approval of the arbitration committee. Is that correct?
It is subject to dispute, but you only quoted half of it because it's also or Article 20.
Article 20, but Article 20 is the joint committee.
Yes.
So how does the joint committee give us a unilateral exit?
Because the joint committee, and this goes to the challenge from the chair at the start of the session, is making an assessment on whether bad faith, good or bad faith, has occurred, and that's the linkage to Article 5. So what you'll see there is within the paragraphs it says, in whole or in part, due to a breach of Article 5 of the withdrawal agreement. So the question for the panel would be whether there had been a breach of good faith, for example, in not being willing to address the commitments, the joint commitments on alternative arrangements, and if so, there would be an exit as a consequence.
But the joint committee isn't a unilateral exit, because the joint committee is joint between us and the European Union. So it would need permission of the European Union to leave unilaterally. Therefore, it's not unilateral.
It's a joint body, but sits independently, yes.
Yes, but therefore, this has been advertised as a unilateral ability. It's not unilateral.
No,
it goes straight back into the withdrawal agreement. And whether it's under Article 20, which requires the agreement of the joint committee, which is the agreement of the EU, which is back to square one, that we can't leave without the EU agreeing.
No.
Well, how is it not?
Because what this says is, again, part of the political debate has been that the UK will be trapped in a backstop. It has no right of ending this, terminating this, disapplying it, whatever phrase. So what is clear here is that, if I take you to a specific line, could ultimately lead to disapplication of the obligations. So the point is there is scope to disapply. The mechanism, you're quite right, through doing that would be through the dispute resolution mechanism within the withdrawal agreement, whether that is Part 6 or Title 3 or through Article 20. But the point is that there is scope to disapply the obligations of the protocol, and that is what the United Kingdom...
But there's always been scope to disapply the obligations of the protocol if, under Article 20, the objectives had been met. This is advertised as a unilateral. I'm focusing on the word unilateral. This is not something the UK can do on its own. It needs, under Article 20, the approval of the Joint Committee, which is a joint committee between the UK and the EU. So we can't leave it without the permission of the EU under Article 20. Is that correct?
So I think there's two things being confused
well,
here.
Let's just focus on that.
Well,
and then we'll come to Title 3 of Section 6.
So what is unilateral is what we're asserting is our interpretation.
Okay.
And the fact, and this comes back to Richard's point, the fact that that is not disputed by the EU becomes common ground that goes before the arbitrator. So this is not saying there is a unilateral exit in that regard, in the regard you're referring to. What it is saying is the ability to trigger, and our interpretation is what the unilateral declaration is referring to.
So that's very helpful. Thank you, Secretary of State. What you are saying is that we have made a declaration saying that under the treaty we can ask to leave the backstop. But that's been blindingly obvious to anybody since the withdrawal agreement was produced. Of course we can ask to leave, but the ability to ask is not the same as the ability to leave, is it?
Well, what this is setting out is that the UK's position, which is it would be entitled to take measures to disapply the provisions of a protocol in accordance with the withdrawal agreement, and that is what it is setting out.
But the only measures it can take under the unilateral declaration is to ask permission of the EU to leave, because it's either on the joint committee or at the arbitration panel. But crucially, with the arbitration panel, because we're covering Articles 167 to 181, is Article 174. Because the arbitration panel is subject to interpretations of EU law as laid down by the European Court of Justice. And we, in the unilateral declaration, are accepting that the only way to get out is with the approval of a arbitration panel that is subject to EU law in matters.
No, with respect, Jacob, what you said is the only way to get out is with the approval of the EU. That is not correct. What this is saying is that the trigger, so what we are asserting here, in essence, is the trigger that we would apply in order to start. Now, where I agree with you is the process through doing so is through the mechanism that is set in with all agreement. But it is about what is the trigger. Now, I come back to where much of the debate has been, and in particular in the meaningful vote, was around the UK being trapped in a backstop where the EU was acting in bad faith, and not just the fact that that would have an indefinite nature, but also it would have a distorting impact on the negotiations themselves, that the UK almost would be required to concede aspects within the negotiation because, in essence, it had no right of access. And what the unilateral declaration is asserting is how we would trigger that mechanism.
But it doesn't mean that mechanism would work. But that's absolutely no change from what was there before. The unilateral declaration
because it's
doesn't add anything, because it simply says we could ask to leave the backstop. Well, we've always been able to ask to leave the backstop. That's not, in any sense, an improvement or a development.
I don't accept that interpretation, and now we'll have a longer session with the AG and his statement. But I think also in a sense, I mean, I said earlier that this is both a question of legal interpretation and political interpretation. The starting point for this is that neither side wants to go into the backstop. There are safeguards to prevent it. What has been negotiated is legal commitments through the alternative arrangements responding to the concerns of Brexiteers in the House around avoiding the need to trigger that. And what the unilateral declaration does is then give further weight to the circumstances through which we could trigger, and I'm sure the attorney will set out further comments on that. But what's slightly lost in all of this is actually there's a huge amount in the deal which we're not getting into because we're into sort of quite a narrow point of legal interpretation between two of us who no longer practice law.
I've never practiced law.
Even
thank you. That Cam wants to move on, but thank you very much.
Now, colleagues, we've got about 20 minutes left. I've got 6 people who want to come in. We can all do the maths. Peter Bone.
Well, very straightforward, Mr. Chairman. Could I ask the Secretary of State, can the United Kingdom, on its own, at any time, pull out of the Irish backstop?
Yes, by triggering a mechanism where if the EU has acted in bad faith, and if the EU has acted in bad faith where that becomes permanent, then there is exit routes through. Now,
can I just stop you to speed things up, Chairman? Clearly that is a no, because it refers to going through other... What I was asking, could the United Kingdom government, if the Irish backstop was in place, said any time, for any reason, it's going to pull out?
Well, as with most disputes between sovereign states, and again, this is a staple of international arbitration. This is how international arbitration works. The arbitrator will make a judgment on the facts.
So
what you're assuming...
No, I'm just asking a very straightforward question. Can the United Kingdom government, if the Irish backstop is in place, say, that's it, folks, we're coming out?
So if what your pitch is...
Any circumstances.
Well, if you let me answer. So what your pitch seems to be suggesting is that the United Kingdom government should enter into an international agreement, make commitments to do so, and then just be able to walk away from that irrespective of the facts before the arbitrator.
Well, indeed, we've already signed up to a treaty that. When we went into the EU, Article 50 allowed us to pull out after 2 years with no say from the EU whether we did so or not. So that's exactly what I'm saying. And what you're suggesting I sign up to and vote for tonight, Secretary of State, is the opposite. Not the right to pull out of the Irish backstop.
No, the point I was trying to land, Mr. Byrne, is the fact that the concern that was raised in the House was the idea that the notwithstanding all the safeguards that prevent going into the backstop, notwithstanding the fact that both sides are committed, and where sadly we should, where much of Parliament's focus, I hope, will be, which is on the future economic partnership. 48% of our trade with the European Union. In practice, we need to have a positive relationship. We've got 3 million EU citizens. As a former health minister, you know, they are invaluable to our NHS. There is a much bigger prize here in terms of having a positive relationship with our largest and most important trading partner. Frankly, we should be focusing our attention on how we build those strong relationships whilst also having what we delivered through the Brexit vote, an international trading policy, control of our immigration, our fisheries policy and all those other issues which are the real prize that for those of us who campaigned for leave, that's what I certainly was campaigning for.
Thank you very much. Vera Hobhouse.
Thank you, Chair, and thank you for coming. So it's all about bad faith. And how that can be demonstrated and what constitutes it, and you've already explained it's about negotiating at pace, and we have already heard that ultimately that is something that might be just an opinion. Now, you said earlier bad faith is a legal term. Could you perhaps show us somewhere a precedent where bad faith was actually successfully demonstrated in the history of that legal term?
Well, what I was seeking to allude to is the fact that bad faith would be an assessment as to whether the EU, and I don't believe that is the EU's approach. I don't think they are approaching these talks in a spirit of bad faith. I think they want to avoid getting into the backstop. They want to get on to having a trading relation. And actually, frankly, when you speak, and I'm sure you have, with many senior figures in Europe, they're getting frustrated with the whole Brexit process anyway. They want to get on to a much more positive engagement and get this done. So the point I was alluded to is just this is a staple of international arbitration, is you have an assessment on the facts. And on the facts, you would look at whether one party or the other had acted in bad faith.
Yeah, but ultimately we wouldn't need any laws if we all just acted in good faith with each other. The whole point of legal disputes are where there is ultimately the assumption of not good faith. So I'm asking you, is there existed and it was challenged that somebody acted in good faith and there was a successful challenge?
I'd refer to the Attorney General as the government's law officer, is probably better placed than me as to which international legal precedents to cite. So
you wouldn't actually know how the government would do that, demonstrate bad faith?
No, well, how the government would demonstrate it is very much addressed in the documentation. So it is through the points, for example, in whether the process set out in the joint instrument had been followed, whether in terms of alternative arrangements sensible proposals have been brought forward. These would be the assessments that an arbitrator would make in looking at whether either side have acted in good or bad faith.
But if it's
not an unusual test.
Thank you very much. Peter Grant.
Thank you, Chair. Can I go back to why the backstop is? Is it fair to say that as soon as the UK decided to leave the customs union and the single market, that created a possible problem as to how to do that, but still to honour our obligations under the Belfast Agreement?
So, you say again, I was just...
As soon as the UK government decided to a potential difficulty as to how we could do that, but the whole backstop issue came to us.
No, so I understand the December 2017 joint report commitments are portrayed as solely a UK responsibility to avoid the hard border. Actually, it was a joint commitment on both sides to avoid the hard border. But I think there's a distinction between what steps are put in place to avoid a hard border and how one protects the single market. And I don't think it's unfair to say that quite often what drives much of the EU concern, notwithstanding that certainly when I speak with people like Michel Barnier, he is absolutely sincere in his personal commitment to the peace process of Northern Ireland, and that comes through very strongly when you speak to him. But underlying the EU approach is very much how they protect the single market, not just the issues of how one avoids a hard border. So I think there's a distinction between what measures you need to put in place to avoid a hard border and what measures would need to be put in place to ensure that the single market was protected in the way that the EU often approaches it.
But the fact remains, doesn't it, that if Irish history had been different, if we hadn't needed a peace process, we wouldn't have problems now with the Irish backstop?
Well, I think firstly there is just a geographical reality in terms of the fact that the Northern Ireland border is the only land border. There's also a historic reality, which is when, for example, we did the work on the alternative arrangements, there is existing technology which works perfectly well on other borders, but which has sensitivities in Northern Ireland. So if you have, for example, tracking devices, then there are parts of the community who quite understandably would have concerns around tracking devices sort of linking to information to the state. So there are historic sensitivities. So you can look at the alternative arrangements purely in a technology perspective, when actually there's also community issues that flow from that as well. So it's a more nuanced issue.
But would that also mean that when people talk about wanting the UK to have the right unilateral at any time to walk away from the backstop, is it still the government's position that you will not even consider that if by doing that you risk undermining or prejudicing the Northern Ireland peace process? Yeah,
so no, I think what you raised, Mr. Grant, is a very important point, which is that notwithstanding everything else, the government has a very firm commitment to avoid a hard border. And the Prime Minister set this out when she went to Northern Ireland a few weeks ago in a speech there. Her absolute personal commitment to avoiding a hard border. And so I think irrespective of the wider debate, that is a unilateral commitment that the British government has given and is something that both the UK government and the Irish government are very committed to.
Thank you.
Thank you very much indeed. Pat McFadden.
Thank you, Chairman. Thank you, Secretary of State. What would happen under the agreement as updated by last night's documents if we reach the end of the transition period? Both sides have negotiated in good faith, but no agreement has been able to be reached on arrangements to replace the backstop.
Yeah, no, it's a very fair point. Well, in the first instance, there would be a decision by the House on whether to extend the transition period. And as you know, Mr. McFadden, there's scope to extend it by a year or 2 years. So that would be the first response to that.
I'm assuming we've already done that, as I say, reached the end of the transition period.
Well, I thought you may then come back with that. And the point is then you're then into a longer period, and I think that's why the commitment that was agreed last night around the timetable for the alternative arrangements is so important. And not just that, just if I can remember where it is, but also where there's a commitment on the EU side in terms of to not unreasonably withhold what may be required in order to facilitate those arrangements. I'll find it later. In terms of facility, could be. Here we go. So, for example, at paragraph 7, where there's reference to the facilitative arrangements and technologies. So, for example, you would look at that in terms of things like the customs code and whether there could be flexibility there. So the point is, both sides have agreed to accelerate the talks. Both sides have agreed to start immediately after withdrawal agreement rather than wait for ratification. A clear time frame has been put in to put in momentum. Commitments on times have been given to alternative arrangements. Now, within your question, there is an absolutely fair point, which is, well, notwithstanding the above, what would happen? Well, we would continue in that instance in the backstop because there's goodwill on both sides.
So
but we are talking, and this is why.
So my question is, if we reach the end of the transition period, assuming it's been extended as you say it might be, and we haven't got agreement, the backstop kicks in.
So if the backstop would kick in that instance, because that is the insurance. But I think what underpins perhaps the best way I can explain this is, do you see the backstop as life insurance, that it's all weather, it's indefinite, or do you see it more like term insurance? Does it have which is where the temporary nature comes in? And the point is, there comes a point over a period of time where it becomes de facto permanent. And the point is, that's when the UK would have, in essence, a right to trigger. Okay. So that's where, to some extent, the politics interplays with the legal interpretation, because there does need to be a judgment, if I may say, of common sense, where there will be a point at which the passage of time shows that it is not temporary.
Can I just ask about this? The government's placing a great deal of weight on this potential for unilateral suspension. Two conditions have to apply for this unilateral suspension element to kick in, don't they? The first is proven bad faith on the part of one party, namely the EU, and the defiance of a ruling from the arbitration panel proving that bad faith. Those are the two conditions. Now, the EU is represented on this arbitration panel, so in these circumstances, the EU would have to agree that it had acted in bad faith for this to kick in.
Well, firstly, so I think what you alluded to is what's set out in paragraph 14 of the joint instrument, and the point is, firstly, the EU doesn't have a majority on that, but secondly, what it says is it would be suspended under that right unless and until. And again, a bit like the political declarations, there's an inherent contradiction sometimes when part of the criticism people made about the withdrawal agreement was the provision of unless and until and its indefinite nature. The point is here, and it's partly why the language was chosen, the suspension would apply unless and until the offending party had taken the necessary measures. So to bring it back to, for example, the alternative arrangements, you've got technology that works. It requires for example, some derogations or some flexibility on the EU part. If after a passage of time the EU was found not to be acting in good faith because there was a way through this, the protocol would be suspended and it would be for the EU then to make those arrangements. Because the bit we're losing sight on here is both sides want to do a deal. Both sides want to have a future economic partnership. So it would then be, the onus would then be on the European side to make whatever adjustments are required to put that future economic partnership in place. And the way that the backstop comes to an end, the primary way, is through a new economic partnership. That is the way, the best way that we come out of it. Now, all of this debate, almost all of this debate so far today, has been predicated firstly on the EU acting in bad faith. Now, I don't think that's the case, and I'd be quite surprised, given often where a lot of the speeches and comments are about the EU, if a majority of the members of the committee genuinely thought that the EU was approaching these negotiations in a spirit of bad faith. And yet almost all our debate is almost predicated on what would we do if the EU acted in bad faith. And I think one should actually look at more realistically at the fact that both sides want to come to a future economic partnership, and it is the future economic partnership that ends the backstop.
Okay. Seema Malhotra.
Thank you, Chair. Secretary of State, we've got a lot more paperwork today. We've got a reprinted withdrawal agreement with the date of March now on it, but in reality it seems that nothing has changed, and we are just a few weeks away from leaving the European Union. Everybody seems to now be thinking that the vote tonight is doomed. I mean, I think you'll be following the reactions to what's just happened even prior to you coming here today. So could I ask a practical point, and this is about our preparedness for leaving the European Union. I have two very brief questions. Firstly, we've got 6 remaining Brexit bills that are yet to complete their passage through Parliament, and that doesn't include the withdrawal agreement bill. So how much time do we actually have, and is it realistic that we're going to be able to pass this legislation before March the 29th, or do you think we're going to need to seek an extension to Article 50?
So there's, if I may say, there's a number of questions within that. So is the primary issue because you started by saying we won't pass it tonight and therefore one can look at no deal issues, or is it if we pass it tonight there isn't enough time for the WAB?
Well, there's two things here. I don't think we are going to pass the bill tonight. So
no, it's just genuinely. I mean, we can address the no deal issues, or is it the time to ratify issue? Because they're two different issues.
Okay, so let's start with the time to ratify. Is there time to ratify if we pass tonight?
So there's no question, and a number of colleagues have sort of alluded to this, that the timetable is tight. But on the other hand,
what are we going to do? Like, say it got passed tonight, how would we get the legislation through?
So, well, I think firstly, these issues, particularly around the withdrawal agreement, have been long debated. So it is not that the House has not had an opportunity to scrutinise.
If I can just ask you briefly, do you think genuinely there's time to get it through, or may we need some sort of shorter extension to Article 50 anyway in order for it?
So we'll have to see. I mean, the question, I think, within the question is, does one need a technical extension in order to pass the WAB?
You are the Secretary of State for DEXU. You must have thought about this. We have to see in the event that, say, the deal passes tonight.
Indeed. No, exactly the point you make. So there's a question. So if the deal passes tonight, will we seek to ratify by the 29th? Yes. Where the House operates. So it partly will depend on the House and the usual channels and the way the business managers discuss this. The issues within the withdrawal agreement have been long debated. And also, there is scope. If I may finish, because it's a perfectly fair question, and I'm trying to give a candid answer. So the WAB is a significant piece of legislation, and the amount of.
There are 6 Brexit bills. There's a lot of work to do. There's about 10 sitting days left after Thursday. How are you going to schedule this? Or are we looking at an extension of Article 50 in order to get...
I'm trying to answer the question. Yeah. So the issues within the withdrawal agreement bill have been much debated in the House. In fact, I don't think that many people would feel that the House has not debated the issues around Brexit and the withdrawal agreement bill.
Could I make it slightly easier for you, because I know we're running out of time. Is what you're saying... let me ask you this, are you confident that we won't need an extension to Article 50 in the event that the deal passes tonight?
With respect, I think it's 5 or 6 times you've sort of come in on me. And what I'm trying to say is there may be the need for a technical extension, if that's the sort of soundbite you're seeking. So
Thank
there
you
may,
for that. And could I ask you this final question?
It
relates back to the question that what the Chair was also raising at the beginning. Look, how long does a technical extension need to be? Because we also know that there is the pressure potentially of European elections following the letter from...
so again, you're opening up quite a significant... So again, we can have a discussion around so the government's policy and
Could I ask you this last question then?
Well, would you like me to answer one of the questions?
Have you had any discussions at all about the potential need for European elections in the event of an extension?
I think the idea of having European elections 3 years after the country voted to leave will be hugely damaging to our democracy.
But that's not the answer to the question.
Would you like me to answer?
No, but have you had any discussions about the potential of it?
Discussions with whom?
Within government.
Well, we've had a discussion to say how much we all agree the idea of having European elections would be completely damaging to democracy, that our focus is on securing the vote this evening, and there is absolutely no appetite whatsoever to entertain the idea of having European parliamentary election. I don't actually get the sense within the front bench of your own party there's huge appetite for that either, frankly. What is very clear from speaking with European leaders is that there's a degree of Brexit fatigue. They have negotiated hard. They recognise that the Prime Minister has negotiated hard, and we have a deal on the table, and they are very keen for us to get on with it. And there's no appetite on their part. Now, the point around debates as to whether one has a technical extension or a long technical extension, a long extension, or how long the extension is it's not within the control of this House. It's not a unilateral decision. This will be a decision taken by the EU 27. And I think the House needs to be quite careful when they look at the vote tonight. They have an opportunity, particularly for the business community, who are crying out for certainty, who certainly in the lobbying they do to me, they say they want the certainty of this deal. They want the deal to go through this evening. They want us to get on to the positive of a future relationship with European countries who we trade with, who we share values with, whose citizens we want to protect, our own citizens we want them to protect. You know, there's a huge appetite amongst European leaders to move forward, and the last thing they want is for this to drag on and then to have questions around European parliamentary elections.
Okay. Well, Secretary of State, there's one place where we never suffer from Brexit fatigue, and that is in the exiting the EU Select Committee. We are very grateful. We're very grateful to you for coming today with all of the pressures, and we're particularly grateful for your commitment to come back before Easter, where we'll have slightly more time. I'm sorry it was a bit truncated, of necessity, but thank you for your answers today. They've been very helpful. Order, order. Right, got to run. Thanks a lot. Thanks.